Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers traffic stops, interfering with public duties, and evading, and is brought to us by Law and Crime Network's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Fume. Cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about moon rituals or sacred crystals. We're talking about our sponsor, Fume, and they look at the problem in a different way. Not everything in a bad habit is wrong. So instead of a drastic, uncomfortable change, why not just remove the quote-unquote bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. Fume is a habit that you're free to enjoy and makes replacing your bad habits easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. I was surprised by how robust and fulfilling the flavors are, and there are a variety of unique flavors that are all interesting and tasteful. I also enjoyed the tactile experience of twisting and twirling the Fume. It is very fun to fidget with. Stopping bad habits is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com/audit or scan the QR code and use code AUDIT to get 10% off when you get the Journey Pack today. That's tryfum.com and use code AUDIT to save an additional 10% on your order today. Thanks again to Fume for sponsoring this episode. On March 28, 2023, a deputy with the Smith County Sheriff's Office in Tyler, Texas, attempted to pull over local driver Cody Voss because both of the taillights on his vehicle were out. Instead of stopping on the side of the road, Mr. Voss pulled into the driveway of the home of his friend Derek Phillips, who happened to be driving in front of him. The interaction that followed was captured on police body cam and dash cam.
Sir? You got a driver's license? I'm Deputy Peters with the Smith County Sheriff's Office. Reason for the stop today, your tail lights were not working as you were driving on the road, okay? And then you immediately pull into a residence.
I literally have a claim that tail lights are not a crime. I'm not involved in the traffic code. I have a notice here. I literally have a lawsuit going on with Nassau PD.
Okay.
And signed by the judge. This is his dad's house.
He's county. Also not driving. Driving's a commercial.
And I'm not driving. This is the county commissioner's house, county clerk. We just pulled in. Which tail light is out?
It was both of them.
I'm outside of your jurisdiction, actually. Who do you work with?
The Smith County Sheriff's Office.
The Sheriff's County?
Yes, sir. Do you have any form of an ID or driver's license?
I do, but I don't have to present it since I haven't.
You do at this point in time because you have committed a traffic offense. You were driving a vehicle.
Code.
I'm not here to argue with you. You have a driver's license.
I've got a dictionary real quick because he doesn't seem to know the definition.
I'm not involved in the traffic code.
So the definition of driving versus the definition of traveling, there's a dictionary.
Okay, let's use this term. You were operating a vehicle on a public roadway. On a public roadway. I'm not, sir. Right now he is being stopped. Okay, you have no involvement.
Okay. Well, actually, I'm actually just being a concerned citizen because I know that
that's fine.
Kill people.
Okay.
So I'm actually just watching.
If you want to be a concerned citizen, add your car, please. You have a driver's license. I can get you out of here.
What emergency do you have? Because if there's not actually a crime or a victim, then you actually can't even use your red and blue lights. We need to see a supervisor.
You were operating on a public roadway.
Stop using that terminology. You're lying. Stop it.
You have a driver's license.
Get your supervisor here for lying right now. You're actually
not at this point in time. If you can provide me with your driver's license.
I'm not.
You have a driver's license.
Yeah, and get your supervisor here for lying on the record.
68.
What's your name and badge number? You're literally lying right now.
Mr. Voss and Mr. Phillips present several arguments regarding the illegality of the deputy's conduct, including claims that he's trespassing on private property and that Mr. Voss was traveling, not driving. In general, courts have consistently upheld the legality of traffic stops conducted in residential driveways for offenses observed on public roadways. And in the 2016 case of United States versus Bean, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, held that a driveway was not part part of the constitutionally protected so-called curtilage of a home, despite the fact that it was partially encircled by fences, because it was open and could be observed from the street, no barriers blocked access to it, and the residents did not post no trespassing signs or take other steps to protect their privacy. For this reason, the court concluded that because the driveway, quote, was not part of the curtilage of his home or of any other constitutionally protected area, the police were permitted to bring a dog onto his property to sniff his vehicle. Therefore, it is highly likely that a court would determine that the officer did not violate the Fourth Amendment by approaching Mr. Voss in a private driveway as part of a traffic stop initiated on a public street. Unfortunately, we do not have time to explore the claim that Mr. Voss was traveling rather than driving at length in this episode, but courts have repeatedly rejected this type of argument as a defense to prosecutions under the traffic code. We've discussed this issue in depth in several previous ATA episodes and a video on our second channel, and I have included links to these episodes in the description below.
Right now, you are being placed. You are detained. You are being detained.
Illegally detained. You're getting sued. You're getting sued, dude.
Right now, I am detaining you, failing to ID.
He's arresting me for failure to ID.
Right now, you're not being arrested.
He's saying he's taking me as Karen.
Right now, you're not being arrested. Step back.
No, you're not
taking me for failure to ID.
You're kidnapping somebody.
Please.
Right now, like I said, you are not under arrest. You are being detained, okay?
That's the same
Illegally
That's the
detained.
same thing. I don't consent to any searches.
His taillight was out. His taillight was out. So now he's
Allegedly.
His taillight's out.
Please, I do not
Look at that, Mom.
While the officer is in the process of detaining Mr. Voss, Derek's mother, Smith County Clerk Karen Phillips, exits her home and asks the officer to explain what is going on.
I'm sorry, can I ask
Not
what's
at this
going
time.
on?
Right now, he's being detained
okay.
because he failed to ID. What I'm trying to do is
His hands on
is
you.
get his ID because he was driving a vehicle
No, he's not
on a
driving.
public
Now you're
roadway.
lying again.
Sir,
What a
it's not about you, okay? This is with him. Where's your driver's
You're
license?
shaking and
at?
it's making me
Where's
nervous.
your driver's license at?
I'm
You're shaking,
shaking.
making me nervous. Under duress, it's in my pocket.
In your pocket.
But I'm not giving you jurisdiction because I'm not operating under the commercial
Okay,
code.
that's
Can
my
I
pocket.
ask
It's in your
why
pocket.
he's in handcuffs?
Because right now, when I stepped out of the vehicle, he refused to ID, okay? What I'm trying to do is identify him. We're going to step back over here so I can get your ID.
Dude, let him drag you.
They're causing issues beyond the point of what needs to happen, okay?
I'm not.
Ah, what a joke, Peter. Dude, you're fired. You are
All right, man.
fired, bro.
Sir,
Don't
you can step back by your car.
Don't even talk to me. Don't say
Just
sorry to me.
lean up against
You're
this
not
car.
in fear for
Can you
your
give me the
life.
keys?
You're on my property.
I'm not taking.
Are you really gonna arrest
Disgusting.
me? Are you serious?
I've said this multiple times. You're not under arrest. I detained you because
It's
you
the same
failed to
thing. You
ID,
don't get
okay?
the-
I'm
if
not
you-
searching. Where
Can
is
you
your
handcuff
ID?
me as a man, and I'll give it to you.
Once we're complete with the traffic stop.
It's not a traffic stop, man.
It is a traffic
You're really
stop.
gonna get in trouble. Can you talk to your supervisor? It's a traffic stop if I'm a U.S. citizen.
Okay.
I'm not a U.S. citizen.
Do you
I'm
have
a
some form of an ID?
I wish you would just talk to me like a man and I could explain things.
What have I done that was disrespectful to you?
No
You
crime
grab me, you're
committed.
shaking, my hands are in handcuffs, I haven't committed a
What
crime.
crime do you suspect is being committed right now?
Mr. Phillips continues to argue with the deputy about various aspects of the traffic stop, and the officer orders Mr. Phillips to step back by his vehicle. Although Mr. Phillips initially complies with this command, he eventually reapproaches the officer while continuing to film him and express his disapproval of the deputy's actions. According to Section 38.15 of the Texas Penal Code, which codifies the offense of interference with public duties, quote, "A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with the peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law." Importantly, the statute also states that, quote, "It is a defense to prosecution under this section that the interruption, disruption, impediment, or interference alleged consisted of speech only." And, as the 3rd District Court of Appeals of Texas noted in the 2000 case of Carney versus State, quote, "Even without this statutory defense, a verbal interference with a public servant or officer could be defended on grounds of the First Amendment to the United States Constitution." In the Carney case, the court held that the evidence was legally insufficient to sustain a conviction under this statute where an individual, quote, "by his argument and his conversation with the officers, delayed the officers in obtaining entry into his home and lied to the officers about his wife's presence, because there was nothing that showed the defendant blocked their entry into the house by physical action. And," now quoting, "arguing with the officers does not constitute an actionable offense, even if the end result is stalling." Similarly, in the 2007 case of Freeman versus Gore, the Fifth Circuit Court of Appeals determined that officers did not have probable cause to arrest an individual under this statute for arguing with them about whether they had the right to search her home without a warrant, even though she was, quote-unquote, yelling and screaming, because there was, quote, nothing to indicate that her conduct involved anything other than speech, or that she physically obstructed the deputies in any way. However, in the 2007 case of Duncantel versus State, the 14th District Court of Appeals of Texas upheld an interfering conviction against an individual who repeatedly ignored officer orders to stand back from a crime scene and stay in a specified area, concluding that, quote, conduct which interrupts, disrupts, impedes, or interferes with a peace officer performing a duty imposed by law is not expressive conduct protected by the First Amendment. Accordingly, although Mr. Phillips could not be lawfully convicted of interfering based solely on his verbal interruptions, it is possible that a court could find him guilty of the offense for disobeying the deputy's commands to stay back. It should also be noted that the Fifth Circuit concluded in the 2017 case of Turner versus Driver that, quote, First Amendment principles, controlling authority, and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions. However, the recognition of this right does not mean that individuals who are expressing their right to film the police cannot be arrested for criminal conduct. And, as the Fifth Circuit explained in the 2008 case of Mesa versus Projan, if probable cause for an arrest exists, quote, any argument that the arrestee's speech, as opposed to her criminal conduct, was the motivation for her arrest must fail, no matter how clearly that speech may be protected by the First Amendment. Accordingly, if Mr. Phillips was arrested for interfering, a court would likely conclude that the officers did not violate Mr. Phillips's First Amendment right to film the encounter, unless it also determined that no probable cause existed for the arrest.
You're searching his wallet?
You know that is unlawful search and seizure.
Cody, would you like me to get it out of your wallet for you? I can't believe you wouldn't give him permission to search your stuff, would you?
No.
Do you want me to get it out for you?
Under duress, if he's saying that he's not going to let me go unless, then you can present it to him. Yeah.
You don't tell me what to do.
You interjected yourself into the
Hey, no! Get off my property!
Get over here now.
No. My property, you piece of shit!
Get over here now.
No! You get over here then! He wants to say get over here like I'm a dog.
I'm asking you for some stupid...
I've done nothing. He's hurting my wrist. He's breaking my wrist. Get off of me. I can't even breathe. Get back. Leave me my glasses. I can't. Stop breaking my arm. I'm not breaking your arm. Get back. Step back. Give me my glasses. I cannot see.
Yo.
You gotta stop.
His glasses are right there.
Those are his glasses, okay. You step out with me.
Hey, don't hurt him. He has not committed.
Ma'am, step
Let
back.
him go! You're hurting his shoulder! You're hurting his shoulder! You put him in the Kimura!
Crap, what is
I have your glasses. I have your glasses.
Get in my glasses. What's wrong? I've done nothing. Please record this. They're kidnapping me. I've done nothing.
I don't know what's going on.
Help! I'm getting kidnapped.
They ran in our house.
I've done nothing wrong. No crime at all. Nothing wrong.
Let's get him in the car.
No!
Yes.
I'm not going with you. I've done nothing.
Stand up.
What are you doing?
Stand up.
I've done nothing. I've done nothing. You're such a piece of shit. I've done nothing wrong.
Get in the car.
Help! Ah, my arm! Oh.
We're 10-4. Anybody else coming, y'all can reduce?
Another officer arrives on the scene and orders Mr. Phillips, who is standing in the garage of his home with the door open, to come over to him. When Mr. Phillips refuses to comply, the officer walks over to him, and Mr. Phillips flees into his home. The officers follow him inside, take him to the ground, handcuff him, and walk him to the police cruiser. And Mr. Phillips can be seen dropping himself to the ground and refusing to move once he's brought outside. Under Section 38.04 of the Texas Penal Code, which codifies the offense of evading arrest or detention, quote, a person commits an offense if he intentionally flees from a person he knows is a peace officer or federal special investigator attempting lawfully to arrest or detain him. Therefore, although Mr. Phillips appears to have intentionally fled into his home after the officer attempted to detain him, he could only be convicted of violating this statute if a court determined that the officer had at least reasonable suspicion to detain him for interfering with the traffic stop. Likewise, Section 38.03 of the Penal Code, which codifies the offense of resisting arrest, search, or transportation, states that, quote, a person commits an offense if he intentionally prevents or obstructs a person he knows is a peace officer from effecting an arrest, search, or transportation of the actor by using force against the peace officer. In the 2013 case of Ramirez versus Martinez, the Fifth Circuit concluded that merely pulling out of an officer's grasp is sufficient force to constitute resisting arrest. And in the 2008 case of Clement versus State, the Second District Court of Appeals of Texas affirmed a resisting transportation conviction against an individual who, after being handcuffed, moved in the opposite direction from the one directed by the officers, continued to resist and struggle, and pushed against an officer on the way to the police cruiser. Additionally, unlike the evading arrest or detention statute, which requires that the underlying seizure be lawful in order to sustain a conviction, the resisting statute explicitly states that, quote, it is no defense to prosecution under this section that the arrest or search was unlawful. Accordingly, while Mr. Phillips's flight would not constitute a use of force sufficient to violate this statute, and due to the angle of the body camera, it's unclear whether Mr. Phillips physically struggled with the officers during his handcuffing, it is likely that a court would conclude that Mr. Phillips at least resisted transportation by struggling against the officers as they attempted to move him to the cruiser, regardless of whether the underlying arrest was lawful. However, it is less clear whether a court would determine that the officers were within their constitutional authority to chase Mr. Phillips into his home to arrest him without a warrant. In the 2021 case of Lang versus California, the Supreme Court held that, quote, the flight of a suspected misdemeanant does not always justify a warrantless entry into a home. Rather, the court concluded that, quote, an officer must consider all the circumstances in a pursuit case to determine whether there is a law enforcement emergency. And although it noted that, quote, on many occasions the officer will have good reason to enter to prevent imminent harms of violence, destruction of evidence, or escape from the home, the court ultimately determined that, now quoting again, when the officer has time to get a warrant, he must do so, even though the misdemeanant fled. Here, at the time the officers chased Mr. Phillips into his home, he was, at most, suspected of interference with public duties and evading arrest and detention, both of which are misdemeanor offenses. Due to the relatively minor and non-violent nature of these offenses and the lack of evidence to destroy, it is certainly possible that a court would conclude that the officers violated the Fourth Amendment by following Mr. Phillips into his home and arresting him instead of obtaining a warrant, even if it concluded that the officers had probable cause to arrest him.
Deputy Peters conducted a traffic stop on this vehicle.
Would you like to accompany me so I can get my flashlight out of your house?
I don't think this needed to go this far. I don't know which
Yes,
one.
ma'am, that's it. Which one of these are his phone?
This is Cody's and Derek's.
All right, let's step back outside.
Doing it. I'm not going anywhere.
You already
please.
did do it. Put your foot in
Please,
the car.
hey, my cuffs.
Put
Please.
your-
They're breaking my wrist.
We'll check them in a
Please.
second when
Just
you
check
calm
it right
down.
now. I'm right
No.
here. I'm not doing anything wrong.
Are you okay, ma'am?
No.
Okay.
This is too much.
Yes, ma'am. I'm not being funny. Do you need a paramedic?
I don't know.
Okay.
After his arrest, Mr. Phillips was booked at the Smith County Jail on charges of resisting arrest, search, or transport, interfering with public duties, and evading arrest or detention, and was released on bond the next day. Additionally, once the Smith County Sheriff's Office reviewed video footage of the incident, a warrant was issued for Ms. Phillips's arrest, and she turned herself in at the Smith County Jail on April 4th, where she was booked on a charge of interfering with public duties for allegedly reaching her arm between one of the deputies and pushing him away from her son as he was escorted out of the residence.
Hey, stop breaking my arm.
I'm not breaking your arm.
Hey, yo, get back.
Step back.
Get my glasses. I cannot see.
Yo,
You gotta stop.
His glasses are right there.
Those are his glasses. Okay.
Ms. Phillips has since claimed that she was not attempting to push the officer away, but rather that she was poking him to get his attention and ensure he took her son's glasses with them. After the arrests, Smith County District Attorney Jacob Putman announced that his office was recusing itself from the Phillips's prosecution and that a prosecutor from outside the county would be chosen due to a conflict of interest, as Karen's husband and Derek's father, Terry Phillips, is a county commissioner and therefore an existing client of the DA's office. On May 9th, Ms. Phillips's son, Lance Phillips, was arrested for disrupting a meeting after shouting about his family's criminal charges and refusing to leave during the public comment portion of the Smith County Commissioner's Court meeting. At his first arraignment hearing, Lance was arrested for contempt of court. and after his second arraignment hearing, a case was set for trial on August 16, 2023. On May 30th, Ms. Phillips filed a $10 million pro se lawsuit against Smith County, its sheriff, and multiple Smith County Sheriff's Office deputies, alleging that the deputies made multiple false statements and violated her constitutional rights. In the filing, Ms. Phillips also claimed that because her personal information was released through the video footage provided to the media, she and her family had been subject to multiple instances of harassment, including drivers honking their horns outside her house for extended periods of time, threatening phone calls, and vulgar emails sent to her workplace. Derek Phillips and Mr. Voss have also filed a lawsuit against the county, claiming that the deputies violated the First and Fourth Amendments and kidnapped them. The pro se complaint requests $150.5 million in damages. As of the date of writing this episode, all of the Phillips' civil and criminal legal matters are still pending. Overall, the Smith County deputies get a C- because although the first deputy generally maintained a respectful and professional demeanor and handled the initial portion of the traffic stop fairly well, both deputies eventually entered Mr. Phillips's home without a warrant to forcibly arrest him, potentially in violation of the Fourth Amendment. Now, while there may be an argument that Mr. Phillips disobeyed the officer's order to stay back during the traffic stop, the first deputy did not protest his reapproach, and the vast majority of Mr. Phillips's conduct was speech, which both the First Amendment and the interfering statute specifically exempt from prosecution. Further, the Supreme Court has specifically held that officers do not always have the constitutional authority to enter a home to conduct an arrest of a fleeing misdemeanant. And in this situation, given the non-violent offenses Mr. Phillips had potentially committed, the lack of evidence to destroy, and the fact that officers knew exactly who they were dealing with, I believe that the deputies had time to obtain a warrant and should have done so instead of potentially violating the Fourth Amendment by entering the Phillips' residence without a warrant. Mr. Phillips gets an F for demonstrating a complete misunderstanding of Texas traffic laws, attempting to flee from the Smith County deputies, and blatantly resisting transportation after he had been placed under arrest. Now, although Mr. Phillips never used the term sovereign citizen, based on the various arguments that he and Mr. Voss made during the traffic stop, they appear to at least believe the sovereign citizen stance on the right to travel, which, as we discussed earlier in this episode, has been consistently rejected as meritless in courtrooms across the country. Now, while I admire Mr. Phillips's willingness to defend his constitutional rights, I would encourage him to conduct legitimate research using reputable legal sources to correct his misunderstandings on the right to travel and other essential issues. Additionally, while Mr. Phillips may have some legitimate constitutional claims against the officers, his conduct in fleeing and resisting strongly diminished his credibility in pursuing those claims. And because Texas law does not give individuals the right to resist an unlawful arrest or transport, Mr. Phillips could be convicted for his resistance, even if the other two offenses are dropped and the officer's entry into his home is found to be unconstitutional. This encounter demonstrates the importance of individuals actually understanding their rights when they try to enforce them, and why it's typically more advantageous for a citizen to submit to an unlawful arrest and then challenge it after the fact rather than try to resist it. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.